publicized water. Must have gotten a new budget or something.
Mostly, yeah.
More money in the budget, huh? Nice.
Slightly. Double your height.
All right, I'll call to order the Planning Commission meeting of Thursday, December 5th, 2024. If we can start with roll call.
Sir, roll call for Chair Dennison,
Here.
Vice Chair Simcock,
Here.
Commissioners Brennan,
Here.
Moran, Commissioner Yu.
Here.
You have quorum to conduct business.
Thank you. I'll look for a motion to approve the agenda as presented.
I'll make that motion.
I'll second.
All those in favor?
Aye.
Motion carries unanimously. Next up are the approval of the minutes of the November 7th, 2024 meeting. Does anybody have any corrections?
I have a correction. Line 33 reads, Commissioner Brennan stated a 20 dive minute visit, nothing to repot. Making a motion to amend that to say Commissioner Brennan stated that he visited 327 Sierra Woods Drive for 25 minutes with nothing additional to report.
I agree.
All right. Did you have any others?
No, that was all I saw too.
All right. Then I will look for a motion to approve the minutes with the suggested edit.
I'll make a motion to approve the minutes with the suggested edit.
A second.
All those in favor?
Aye.
Motion carries unanimously. Next up is our council liaison report.
Good evening, Commissioners. It's good to be back here. I'm going to apologize in advance. I'm going to dine and dash. I have a family matter that came up that I couldn't stay for the whole meeting, but I'll be listening online. Commissioner Yu, you mentioned the city budget. That's actually really timely because that's the one thing I
Nice.
was going to talk to you about. So thank you for the tee up. So I wanted to give a report that just came out recently from the California Policy Center. The California Policy Center ranked the city of Sierra Madre, its fiscal strength 87 out of 100 in their rating. And we are ranked, I think 55 out of 414 cities in the state, which is really good. And this is a report card. So we get graded on a whole bunch of things. And our overall
grade is an A, which is great. We get an A in general revenue reserves. We get an A in debt burden. We get an A in liquidity. We got a B in pension costs, an A in pension funding, a B in pension obligations, an A in OPEB obligations and OPEB funding, which both those have to do with amount of benefits, and then a B in net worth. However, we get a C in revenue trends. And what it says here is that the average growth rate of revenues over the last 3 years is very low for a city our size. I bring this up because, as you may have known at the election, Measure PS did not pass. We are going into this next year, or we're going into the upcoming fiscal year, the one that starts in July 1st of this year, we will have a budget deficit. And so we're going to be looking very closely at how we can address that. The city manager has put together a task force of citizens to try to look at revenue options for the city. But right now it's a structural deficit, meaning that we have to actually stop doing some things to be able to afford our basic budget. And it is going to be significant and growing over time. So I bring that to you because it's probably going to come up in a lot of other forums. We're taking this to all of the commissions so that you're aware of it, and it will be probably a major topic of 2025. And that's all I have to report. Thank you for the opportunity.
Thank you. All right, next up is community input. At this time, any person may address the Planning Commission concerning an item that is not on the agenda. The Commission welcomes your attendance and participation. When addressing the Commission, please begin by providing your name and address for the record. Please keep comments to no more than 3 minutes to assure an orderly and timely meeting. I'm certain people are holding their comments for the California legislative updates. But first, let us move on to the consent. So we have, do I just read this and we vote on it, or? Yeah, okay. So it is recommended that the Planning Commission approve the cancellation of regular Planning Commission meetings on December 19th, 2024, and January 2nd, 2025, and January 16th, 2025, respectively. So I think first we need a motion, and then we take public comment before we vote?
You take public comment before the motion.
Okay, great. So at this time, anybody who would like to come forth and speak to us about the proposition of canceling the meetings on December 19th, January 2nd, 2025, and January 16th, 2025, may come forth and speak. Hearing none, we'll bring it back to the commission. Would somebody like to make a motion?
I so move.
Second.
All those in favor?
Aye.
Motion carries unanimously. Next up, we have a presentation from staff on the online permitting system.
Our assistant planner Huang will be delivering the presentation.
Very excited to see this one. It's gonna be good.
Thank you, Planning Manager Lynn. Good evening, Planning Commissioners. Staff has prepared a presentation for the new online permitting and licensing system the city will be using called Acela. Previously, we've looked at this topic and mentioned that there are 4 modules: licensing, building, planning, and public works. And we reviewed the licensing module, and tonight we'll be doing the planning module. Since the previous meeting, to provide a brief update, since the last time we talked about this, staff has launched the licensing module in this past October, and we've received 86 applications so far. Payments and license records have also been accessible on the citizen portal, and additional user guides have been made and provided to citizens and users to aid them in common tasks in the program. This program is in response to State Mandate Assembly Bill 2234, Post-Entitlement Phase Permits, a bill that requires cities and counties to electronically process post-entitlement permits such as building, mechanical, electrical, and plumbing permits with the provisions listed below. So far, staff has completed the first 2 and now focusing on the last one, create an online permitting system to allow applicants to apply, complete, and retrieve their permits online. And staff has been working on finalizing these modules and soft launching the program with the license renewals and also testing a few planning applications. So to access the citizen portal, you'll go to the website page. Similar to the previous licensing website page we reviewed, there is general information and some frequently asked questions with user guides attached to assist users on how to do common tasks in Acela. Ultimately, the applicant will click the box on the top right that's indicated Citizen Portal, and it is linked to the Acela Citizen Portal website. And once they click that, they will access the homepage for Acela, where the applicants can create an account and also create applications. To register for an account, they will either click the top right where it says register for an account, or on the bottom, create an account, and it will ask for some general information and also a contact type such as applicant or business owner, etc. Once an account is registered and logged in, this is the homepage for Acela that the applicants will see. There is a selection of different modules on top, and to access the planning, you will click the planning tab indicated in the red box, or you can go to the overview on the bottom where it has all the modules, and you can access application types. And once you click the planning tab or module, you can access planning records or application history. And in the photo, there is an existing record. That's what it will look like. And to create an application, an applicant will click Create an Application indicated in the red box. When creating an application, the applicant will then select and complete the application depending on the type of planning application. The question mark icon on the right of each type will also preview the subtypes of the application, such as accessory dwelling unit or conditional use permit application under entitlement. A common application that is applied for our entitlements, and multiple can be applied for in one application through Acela. And the applicant will select the number of entitlements being applied for in rows, and then select the entitlement type. Another feature in Acela is that you can also upload documents such as design drawings or photographs for staff to review. And it also allows staff to provide comments or red lines on the uploaded documents where applicants can have access to them on their account portal when completed, or even check the status for them. This promotes a sort of transparency and efficiency in project and plan reviews. After completing uploading the documents, you can review your entire application, confirm the information that you put into the application, and then submit for a staff member for review. And that completes my presentation. Thank you.
So one of the things that I've heard from the community is that the staff does a great job of working together with applicants and iterating on design before it gets completed. Would you say that most of those projects that are collaborative, such as that, will not be hampered by this new online process? Or do you worry that this will hamper some of that collaboration?
There is a sense of communication also in Acela that can be utilized between an applicant and a planner or project reviewer through Acela. So
well, I guess it could also just be that there's a bunch of projects that simply don't require much of that collaborative interaction, and those will be well handled by this. But I assume it's still acceptable. Not everything has to go through the portal. You can still come in face to face and set up meetings and work collaboratively that way.
That is correct. You can still meet with a planner or a building plan checker at our front counter. But the end goal is to have the applications to go through Acela and be processed through there.
So then would the process be that someone would come and talk to the planner, kind of get a sense for what they need to do, and then they're given the information, and then when they're ready, they submit everything online? Is that, okay.
That is correct.
And then if there's a need to have that collaborative session, that's when the planning staff might reach out and say, you can either submit your changes online, or we can get together and just hash this out.
That's correct. The process won't be completely asynchronous. They can still come in and inquire the planning department.
The hope being for the majority of the simple ADUs and smaller projects that the asynchronous version of this is absolutely perfect. Okay.
So most city websites that I deal with when I submit anything, there's there's a lot of documents that kind of go over, if you need this, then you should take this step and take that step 2, 3, and 4. Is there a document like that that's on the website that people can reference if they don't need to come in and take a look at it? Because depending on the type of project, for example, you don't need to go to plan, you just go straight to building, right? Or in certain ones, you need to go to both, and you get the fire, and everything is all one application. So is there one place that you go to for that? And I think that could be really confusing to somebody that's not familiar with the process, right? And that's why it helps to come in and say, what do I need? And then you tell them, right? So.
Right, so we still recommend speaking with a planner or consulting with someone before submitting an application to ensure that you're submitting the correct documents. And they can do that either via email or come to the counter or through the phone as well.
Okay.
And then we also have application checklists on our city website that provides a guideline of what to submit for specific entitlements or applications too.
Okay. I guess I can give you my input after I go through it. I haven't gone through it lately, so, okay. Thank you.
Any other questions for staff? All right, thank you very much. All right, next up, we have a discussion on California legislative updates. My favorite presentation.
So Chair, this is likely part 1 of 3, most likely, because just as years past, there's no exception. There's been a lot of legislation in the housing and land use space. I'll talk about really quickly what this presentation covers and what it doesn't cover. This presentation is going to cover all those streamlined developments, like your ADUs, your SB9s, your AB 803 styles that we've adopted in the past. I'll talk about what some of those are. But all those streamlined, ministerially approved developments, that these new ones that exist now, it's going to cover that. What it's not going to cover is like Housing Accountability Act, CEQA amendments, density bonus amendments. And the big one this year, it seems like the legislator always chooses a theme. And the theme this year was fees for development. And there's a lot of reform this year with respect to how much we can recover and what we can charge developers when they're building. I think that'll be a presentation in and of itself. So you've probably seen this chart before. It's massive. And it's updated. I try to update this every year. It's probably illegible to people. That's why, Caitlin, if you can go to the PDF version, and I just want to scroll over the top columns so people can see what we're actually trying to capture. So if you could zoom into the top, yep. Okay, so the way this decision tree works is, when we're dealing with the development, the first question we ask ourselves is, how many units are we contemplating? The next is, what zone is this going to be built in? Then we ask, is this going to be a market rate development or an affordable development? If you could continue scrolling to the right there. Then we talk about type of development, right? Like ADU, SB9, there's a lot of other specialized ones we'll talk about today. If they're over 5 units and they're affordable, you can qualify for a density bonus. I cite the relevant statute. We find out, I know whether a hearing is permissible or not. And I talk about the level of review that we're authorized to consider the item, and then whether there's a CEQA exemption. So that's how this decision tree works. If we can go back to the presentation, and we will go to the next slide there. Now this next slide focuses just, go back up. So in this next slide, what I'm trying to focus on here is a single unit of housing in the single family zone. So that's the context we're talking about now. So next slide. And so we have 2 big ADU laws this year. Click through. So under existing law, the city cannot deny a permit for an unpermitted ADU built before 2018 unless it makes a public health and safety finding or that the ADU is deemed to be substandard. And substandard is like, there's a definition for it under the health and safety code. Basically, it's what you think. It's like rats, leaky walls, bad plumbing, all that stuff. This law came about in 2018 because the state realized there are a lot of unpermitted ADUs in every city, and they don't count toward RENA, and often they are substandard, or they have some kind of, they weren't built up to code. And what they were trying to do is they were trying to encourage all these people who built these illegal units to contact their building departments. And they said, we're not going to punish you. We just need you to comply. So contact us. If we find that it's substandard, we'll have to have you fix it. But otherwise, even if you built it improperly without the proper permits, we're going to let it go and keep you, we're going to add you to the RENA list, the number of housing in the city. Under this new law, this deadline, so before it said ADUs built before 2018, now it's ADUs built before 2020. So during 2018 and 2020, if any illegal ADUs were built, they can qualify for this amnesty program too. Also, the city must create a checklist of conditions that would render a building substandard and post it to the website. That list is already in the state code, but a lot of people don't know how to search for that. So one of the things we're going to work on with staff is developing this list and posting it to the website. Under existing law, the city cannot charge water and sewer service connection and capacity charges for converting structures to ADUs. So if there's a garage, someone converts it to an ADU, and they're using their connection, the water connection or sewer connection that was for the house, and they just extended the lateral, then we can't charge them a connection and capacity charge under existing law. Also, the city cannot impose development impact fees on ADUs less than 700 square feet, and only a proportionate development impact fee on ADUs greater than 750 square feet. So this is a big deal in terms of city finances because people are building units, they're impacting the system, and we can't recover the cost for that impact. Under this new law, unpermitted ADUs need not pay impact fees, connection charges, or capacity charges except when utility infrastructure is required to address substandard issues. So the old law only applied to permitted ADUs. Now unpermitted ADUs get these same cost benefit, these same cost savings. So it's a good deal for those who built unpermitted ADUs, frankly. Okay, now switching our focus. Now we're going to talk about multiple units in a single family zone. Again, another ADU law. Under existing law, the city is prohibited from requiring replacements of garages, carports, and off-street covered parking when converting ADUs. Right? We have that in our code now. This new law adds uncovered parking spaces to the list of off-street parking types that don't need to be replaced. I think that was already our policy, but I guess for some cities it wasn't, and the state clarified. Existing law, multifamily developments may seek ministerial approval for up to 2 detached ADUs. So if you have like a condo or some kind of duplex or something, you got a under the prior law, under the existing law rather, this law takes effect January 1st. Under existing law, the maximum number of ADUs you can get for a multifamily development is 2 detached units. Now, for an existing, that's the key term, for an existing multifamily development, up to 8 detached ADUs, but the allowable number of ADUs may not exceed the number of existing units on the lot. So if you have a 4-plex, you can get up to 4 additional ADUs. So it's like 8 units. But if it's a proposed multifamily development, so it hasn't been built yet, just proposed, you are still limited to the 2 detached ADUs. I don't know why this distinction exists, but there you have it. So if you have a multifamily development, you can get up to 8 additional detached ADUs.
So, if you were to find one of the existing multifamily units I'm thinking of Dr. Brown's old office that's 2, and right next to there on the boulevard, there's a 3-plex. You're saying that under this law, you could put 2 on the one that has 2 units and 3 on the one that has 3 units?
Are they separate parcels? Or are they one parcel with 2?
One parcel with 3 units on it.
It's one parcel with 3 units on it, then they can get an additional 3 units.
And those, because they're ADUs, would be subject to the lesser setbacks and ministerial approval up to 1,200 feet.
Yeah, and I mean, I don't know how many people generally live in ADUs, but imagine there's all these impacts that come with that in terms of traffic and sewer and water and financially, we can't account for it. We just kind of have to absorb that cost.
And we were not allowed to prohibit height.
No, there is a height limit for ADUs.
There is a height limit, okay.
There is a height limit, yeah. I don't
Okay.
recall, is it 16?
16 feet, yeah, 16.
16 flat, 25 with pitch.
He's confirming.
18 feet in multifamily zones, up to 25 feet if it's attached to a 2-story building.
Thank you.
Okay, sticking with the multiple dwellings, but in a single-family zone context, let's turn to SB 9. We have an SB 9 ordinance on the books. It now needs to be amended. Under existing law, up to 2 residential units within a single-family residential zone are allowed, and they can be approved ministerially. So you can have a duplex in a single-family zone. If the development complies with objective zoning subdivision design standards and does not allow for demolition of more than 25% of the existing exterior structural walls. Again, I'm not really sure why, but the legislator got rid of that requirement that they not remove or they not demolish 25% of the existing exterior structural walls, so that's no longer a thing. So now they just need to comply with the SB 9 law and our objective zoning subdivision design standards. But it also interestingly prohibits cities from imposing zoning subdivision design standards that are more restrictive than the standards that exist under the underlying residential zone. So what cities were doing, lots of cities are doing this. I think we might even have 1 or 2 on the books where we've adopted, cities were adopting standards that are specific to SB 9 developments and that are more restrictive than what you would find in the underlying single-family zone. And the state said you can't do that. Whatever the underlying standards are for the underlying zone, it can't be more restrictive than those. It can be more lenient than those to encourage SB 9 developments, but it can't be more restrictive.
What's an example of something like that?
Like, let's say height. If the height limitation in your single-family zone is, I don't know, 15 feet, and you said SB 9 developments can only be 8 feet, that would be an example of more restricted development standard.
Now, the single-family residential zone is the only zone that we're allowed to do subjective review. Or not, design review, sorry, not subjective
Design
review.
review, yes.
Design review. Whew, I almost got in trouble there.
Yeah, yeah.
Whew.
Correct.
Sorry, I started in 2017. We had a lot more ability to do stuff then. This does not prohibit, this continues to allow us to have design review for SB 9.
No, we never had design review for SB 9.
Okay.
SB 9 is like an ADU,
Okay.
ministerially approved.
Do we have
That's
any
why you've
SB
never-
9 projects in the city?
We have a couple proposals, but they never submit application.
I'm glad you asked that because I have it in my notes here. SB 9 has been a big flop so far.
Yeah, I don't know many projects that, yeah.
So I have the numbers, and so the legislator's trying to amend this because they're not getting any traction. I have the numbers here. In Los Angeles received 211 applications for new SB 9 units in 2022. All of Los Angeles, 4 million people.
Yeah.
They only got 211 applications. San Diego city only got 7.
Yeah.
So these things aren't being built. Now, if you read the legislative history, the legislator thinks that this is like the ADU law. The ADU law was slow. In 2017, when all those reforms happened for ADUs, people weren't building ADUs either. ADUs started getting built like 5 years later. In 2021, 2022, 2023, it really picked up. So that's what the legislator's banking on and is hoping to make it. They think once people figure out how to use this law, more people will build under SB 9, or at the very least subdivide their lots, because SB 9 allows for lot subdivisions too, which I'll get to next. Also on the SB 9, the city under existing law has 30 days to determine the completeness of an application and 60 days to determine whether there's a consistency with the development standards. This doesn't really change things that much, but they've just kind of created a little more refined shot clock that says we have 60 days, like the ADU law, frankly. We have 60 days to issue an SB 9 permit upon receipt of a complete application. So it doesn't really change anything, I think. It just makes the language, it parallels the language with the way things are written under the ADU law.
But the SB 9 developments, they aren't standalone ADUs, right? They're kind of like a JADU?
Yeah, I wouldn't even think of them like an ADU, because the ADU, the idea of an ADU is you have a primary, and then that's your secondary unit.
Yeah.
These are two primary units on one lot,
Yeah.
is the idea. But you can also choose to build a single-family home using SB 9 in the single-family zone. The advantage to SB 9 is you'll get it through ministerially. The disadvantage is the development standards are much more restrictive than what you could probably build under our existing code. Okay, sticking with SB 9 here. If I'm not sure if folks were following, but a court determined SB 9 is unconstitutional as applied to charter cities, but the decision was silent as to general cities like Sierra Madre. The legal reasoning here was really interesting. So cities and counties have something called police power. Police power under law is like very broad. There's a lot of things we can do under police power, and one of those things is land use authority. So local government has land use authority. The only time local government doesn't have land use authority is when there's an issue of state interest that will trump our land use authority. So the state has to identify specific interest and say, this is a state interest. We have to put aside your local interest, and the state interest will control. Now, the justification for all these housing laws is we have to build affordable housing because there's a shortage of affordable housing, and that's why the state's coming in and overruling the cities. Interestingly, for SB 9 and frankly ADUs, these are not they don't contemplate deed-restricted affordable development. They're just promoting new development. So the argument was made, well, if these aren't deed-restricted affordable, then why are you telling us that you have the authority to overrule our local decisions? Because this doesn't promote affordable housing. This just promotes housing. And the court agreed with the cities. And so now what the legislator did is they added some new language to SB 9 that says, basically they're making a supply and demand argument. They're saying these are units at ADUs, SB 9s, that aren't deed-restricted affordable, but they're affordable by design because they're smaller and they increase the supply. And so therefore, they do promote affordable housing. So the legislator is using their angle, and then we'll see what happens on appeal, because this is going to the Court of Appeal. Under existing law, the city may deny an SB 9 development if it finds specific adverse impacts upon the public health and safety or the physical environment. Now this line at the bottom here, impacts on public health and safety or the physical environment, appears everywhere in all these housing laws. It appears in the Housing Accountability Act, in the density bonus law, SB 9, but slowly they've struck out this last part, impacts on physical environment. They struck it from the Housing Accountability Act, and they just struck it from SB 9. So now we can only focus on specific adverse impacts upon public health and safety, not the physical environment.
Can you give me an example of a public health safety issue and a physical environment issue?
A public health and safety issue is like if your development is built in such a way that we can't connect sewer to it, then we're not going to authorize that. We're not going to ministerially approve it because you need a sewer connection and there's a public health and safety issue if you don't have sewer, for example. The physical environment one is trickier. I don't exactly know
Yeah.
what that one looks like. I've never dealt with it. But I assume people were using it. That's why the legislator struck it.
You can't displace bumblebees in order to put a
Yeah, maybe.
house there.
I mean, something environmental, I assume.
So Alex, for the public health and safety, let's say if we have substandard roadways and substandard access from a area, would that be a
Yes, and we've talked about this. I know we've talked about this in the context of the canyon before, and I've always made the case that I think that definitely is a public health and safety issue. What we considered doing, but I don't think we did, was designating the entire canyon area to be off limits to ADUs and SB9 units. I think at the time we thought that might be going a little too far. But on a case-by-case basis, I don't think I have any issue arguing that some streets are just too narrow, too dangerous to impact them with a lot of traffic. Okay, now, switching again, now we're gonna talk about multiple units, but not in a residential zone. So in non-residential zones. This is, can we go back to the PDF here? This is a really new phenomenon. This is something like we've never seen before. ADUs have been on the books for years. They just weren't as aggressive in people developing them and in how lenient the laws were. But this is totally new. Residential development. If we could scroll right in that middle, the purple in the middle, if we can scroll into that and just make that bigger. Perfect. So this is all new stuff. Last year, a bill passed to make affordable housing in school districts a thing that can be approved ministerially. The hotel and motel conversion law was passed last year too, AB 1490. I'm just going from top to bottom there. That was building on the, what was that? What was it called?
home key?
Yeah, home key, right. Home key and room key, the governor's initiative, and they turned it into a law. University and religious institutions now can have housing, and they can pass that through ministerially. This last one is what I'm going to talk about, though. Office retail parking conversion. This is the one the legislature is really focusing on because they feel like there's a lot of potential here with these big stores closing down as a result of the Amazons of the world. So we can go back to the presentation. Again, none of these are not in residential areas. They're either in institutional or commercial zones. All right, perfect. Okay, so this new law amends the Middle Class Housing Act of 2022. So under the law, it provides that a housing development project is an allowable use on a parcel that is within a zone where office, retail, or parking is a principally permitted use if the proposed development complies with specified requirements. Now, why was that a big deal? It was a big deal because it got around CEQA. Before, you want to convert commercial into residential, there's all these environmental studies and everything you have to do to get your EIR certified. You don't do any of that now. By right, if it's a commercial zone, you can build residential if it meets these requirements. It also authorizes ministerial approval if you have a sufficient number of affordable housing units. The project site must be 20 acres or less. And there was just a minor edit to this law. Now, if you're a regional mall that's closing down, the site can be converted into housing if it's 100 acres or less. So think Santa Anita Mall probably. If it ever closed down, they can convert that to like massive housing.
So on this one, any of the commercial storefronts that we have could be converted?
Any of the commercial storefronts can be converted, yeah. 20, yeah, below 20 acres, definitely. Mm-hmm.
So somebody can just buy one of those buildings and convert it to a house and live right on the boulevard?
Right. They would have to build affordable housing, but yes.
For the ministerial approval?
Yeah, I think I'd have to look at the law again, but I think this law only contemplates ministerial approval. Sorry, it only contemplates affordable housing. You can't build
Got it.
market rate under this law.
Okay,
Oh, okay.
that doesn't pencil.
Not yet.
All right, so there's another law, affordable housing, same concept here. Multifamily developments. It limits developments. Sorry, 1 second here. Right, okay. So under existing law, the city is limited to applying this Affordable Housing and High Roads Job Act, which kind of does similar things with commercial zones. It only applies to developments sites no greater than 20 acres. This expands it out to 100 acres for regional malls. Again, the legislators contemplating a lot of malls closing down because that's been the trend across the country. Currently, it's prohibited within 500 feet of a freeway, because if you see what the Air Quality Management District says, it's really dangerous for people to live within 500 feet of a freeway. It's even worse for those sensitive populations like the elderly and children. They've struck that requirement if there are sufficient filtration and air quality standards in that development to allow for development within 500 feet of freeway. It adds site requirements prohibiting demolition of historic structures, prohibits development within certain coastal zones, establishes approval timelines. I won't get into this one too much. We're probably never going to see this one in Sierra Madre. This is something that the city of LA is going to deal with most likely. And the last part of these streamlined developments are multiple units in a multifamily zone. So your R3s, R2s plus. So the Starter Home Revitalization Act was adopted last year as well. I'm sorry, it was adopted 2 years ago. I just want to give a little bit of history here. We adopted in our municipal code, chapter 17.58. It's AB 803 was the law at the time. I think it was back in 2022. They're called small home lot developments. It's an interesting concept. Whereas it does the opposite almost of SB 9, or like an ADU law. What SB 9 does is it takes a single family zone and it makes it a multifamily zone because you're building 2 units in a single family. AB 803 kind of did I think kind of does the opposite. It takes a multifamily zone and allows you to chop it up into fee simple parcels and sell those individually. So you're gonna have a bunch of tiny homes in bunch of tiny single family homes in a multifamily zone. Again, kind of a flop. We didn't get a lot of development under AB 803. I don't know if have we ever seen an application? The state doesn't really see these applications. So it's kind of a flop. Again, probably something that a lot of developers don't know how to use, but it's also difficult to use.
So an example would be if you have one of those great big R3 lots going up Baldwin.
Uh-huh.
You could chop it, instead of having to comply with the minimum 12,500 square foot lot for an individual home, you could use this in order to put 3 small lots.
7,000?
Or 7,500.
Yes.
Yeah, but,
Ministerially.
yeah, so if you had a 14,000 foot lot that was R3, you could never subdivide it. But now with this, you would be able to subdivide it into
And the
some number
standard's
of units.
much lower, by the way. It's not 7,500. It's like 1,500 or something much less.
So you
7,500.
could put the proverbial motor court
Yes.
onto it.
Yeah. It actually contemplates. I forget what that term is, but it's like those little villages. you know what I'm saying? It's like a bunch of different units. So they're all single family units.
Yeah,
Yeah, exactly.
they're the one on Grandview.
Yeah, right,
Yeah.
exactly. That's the kind of development AB 803 contemplated.
Okay.
Now, it didn't really get anywhere. So, in 2023, AB 803 was 2020 or 2021. In 2023, the legislator adopted SB 684. That was AB 803, but on steroids. It's more lenient. You can do a lot more with this SB 684. I won't get into the details, but just know it's limited to 10 or fewer development units in the development, but it's a lot more flexible than AB 803. Limited to multifamily zones no larger than 5 acres. Under this new law, it extends the application, this is new, extends the application to vacant lots in single-family zones no larger than 1.5 acres. Which seems like, in my mind, kind of a logical extension of this, because you're really building single-family homes. But it's unusual because they took a multifamily law and they threw it into the single-family zone now. So vacant lots in single-family zones no larger than 1.5 acres can be subdivided ministerially with units built on them ministerially, multiple units. Those single-family zones, the newly created parcels, are no smaller than 1,200 square feet, and that's actually the standard in AB 803 and 684. 1,200 square feet.
The lot.
Minimum lot size, not minimum unit size.
Yeah.
There's a minimum unit size too. Under existing law, the application that's submitted must include at least as many units as the maximum allowable residential density. That was the big sticking point. A lot of people couldn't build up to the maximum allowable residential density. Now, the application must include at least 66% of the maximum allowable residential density or 66% of applicable density. So they're just creating more flexibility here for the developers. The housing development project, again, may not exceed 10 units under the existing law. But as of January 1st, the legislator clarified that ADUs don't count toward that 10-unit limit. So now combine the ADU law we just learned about with this law. If you build, let's say, 8 units under this SB 684, you've taken a multifamily lot, you've subdivided into 8 units, you can get on that same lot an additional 8 ADUs behind it for 16 total units, and you can do that in like a R2, R3 something. It's just interesting to see if this will all play out. I know we were all as city attorneys very concerned in the beginning, and it seems like a lot of our concerns weren't founded because developers just aren't building these. So it'll be interesting to see in 5 years if we come back and we're seeing these types of applications or not. So that concludes the presentation on different housing types. The next time I come back with this presentation, we're probably going to focus on amendments to CEQA, the Housing Accountability Act, and density bonus law.
So I had a couple questions about that last one. So we have zones that are like R20, and so that was the challenge they were having, is that they had to be.
They couldn't meet it.
They couldn't meet 20.
No.
On that.
They can't meet 20.
But an R3, I mean, now you only have to get 2 houses on it.
Right.
But 3 would be easy on it with a minimum 1,200.
Right.
You can easily go find a 7,500 square foot R3 lot.
Right.
And divide it into 3 2,500s.
And
then have room to not only do that, but put an ADU behind every one.
And I don't know if it was the commissioner or it was staff, but like we've talked about whether some of these zones even mean anything anymore. Maybe we should get rid of like an R2. Doesn't really mean anything anymore. And why we even have an R2 in our code. So anyway, something to think about in the future. But yes, it's most applicable to these lower density ones. The R20s though, that's really, those are part of our RENA. And those R20s contemplate affordable housing going in. So all these things I've talked about, none of them are really affordable housing. This is all just affordable by design, small units.
Alex, and the presentation materials will be available to us?
Yeah.
Or,
Are they up on
need to
the
look at it.
agenda packet?
I'd like to,
Okay, yeah, we can include them in the agenda packet.
that'd be appreciated.
You still have to meet like parking? Or
For
do they just get rid of parking for those?
these types of
Yeah,
developments?
for
here?
these little 1,200 square foot.
I think there is a one parking space per unit requirement in that state law, as there is for ADUs, by the way. So they just know they've got rid of the replacement parking requirement. So if you had formerly like 4 parking spaces, now you only need 1 per unit.
Do you have an opinion on why some of these new laws have not produced additional housing? Do the economics essentially just not make sense potentially then, based on
Yeah.
the construct of understanding what they're trying to achieve and what they're trying to promote, but when you actually get it into a commercial framework, it doesn't work economically from a developer?
Perspective. Yeah, I can't speak from a developer's perspective because I don't know the economics of it, but I will say that these laws are complex.
Mhm.
As a city attorney, I have difficulty applying them sometimes, so I can only imagine. And I mean, I don't know. This isn't really intended for house flippers. This is intended for people who own their properties to develop them out and to sell them or to rent them out to people. I mean, that's how the ADU law was written. It wasn't. SB 9's written that way too. There are protections in place to prevent short-term rentals, house flipping. So for an unsophisticated developer, just a resident, to use these laws, that can be very difficult without staff guidance.
I don't think it pencils out either. I mean, to build a unit, to be able to rent out for, and yeah, it's,
And with the high density impact, it seems challenging.
And I think that, I don't know that that's a fair assessment that the legislature had about the ADUs being slow to take off. I think that if you look at the time they really started skyrocketing, it was when everybody was trying to upsize their domicile because nobody left home. I mean, COVID is when we really saw ADUs start to take off, and it was a really easy way to convert your house, and then people got more familiar with it. I think the complexity and for now, while they leave the mandates of living in the house for so long, that they're going to continue to not see those. But we've seen them chip away at all of those constraints over time. The only reason I bring that last point up is that hypothetically, the same way that the R1, R2, R3 designations are probably legacy designations that don't apply much anymore, you could see reason why you would push everything to a very high density, so that until they strike like the 66% and bring it down to 50 next year and 40 the year after, that might be prohibitive to constructing some of these.
Yeah. And I don't think people have really have figured out how to market these yet, because I see all the time people who, like the ADU expert, and they advertise their services and how to convert your home and create an ADU. I've yet to see anything like that for SB 9 or AB 803 or any of these, so it seems like the market hasn't really caught up with these laws yet either. There's a marketing opportunity there, commissioners, if you
Or it's a bad fit.
or it's a bad fit.
yeah, because if you're sophisticated enough to go through all of this and build it, you're gonna do the larger project. You're not gonna be messing around with something small, so.
Sure.
Yeah.
All right, thank you.
All right. Any other questions for Mr. City Attorney? Thank you. That was a great presentation. Planning Commission reports.
None.
All right. Planning and Community Preservation Department reports. Acting Director Lynn.
Thank you, Chair. So we're looking to cancel the next 3 meetings, and coming back in February, we'll have a tentative parcel map for the 700 North Sunnyside Matador Rosa site. Following that, we'll have a EIR coming our way for the Ginkgo Grandview project. That's all I have. That concludes my report.
So if I recall correctly, we have a total of 5 meetings allowed for the tentative track map? Is that right?
Right.
So we will want to make sure that we let fellow commissioners know it's going to be a long 3 meetings in a row, or however, I assume that we'll need to reserve at least 1 meeting, if not 2, for the city council in case there's an appeal. So we'll basically have 3 meetings to get through all of it.
Well, the map isn't going to be subject to appeal. It's going to go to the city council for approval, right?
Right, so this tentative parcel map is dividing the existing Madre Dolorosa site into 2. Remember, in the specific plan and the development agreement, Madre Dolorosa agreed that on the northern portion of their property, they're going to be a restrictive use for open space. So this is just to divide it into 2.
Gotcha.
And have a restricted covenant on it.
The developer isn't bringing this application. The congregation is bringing this application.
Okay. Okay. Because we're still just about a year and a couple months away from actually seeing the next step.
Yeah, so the 2-year time limitation for the tentative track map is coming up in May 2025.
Oh, okay.
So City Council will be reviewing their final track map. And before May 2025, they will need to submit the design review for the single-family home.
So the design review comes to us, and so that's the one that we'll need to complete within 3 meetings or so.
Right.
So we-
But the tentative track map does not come before us? It goes straight to city council, you said?
You already got the map.
Okay,
Right, Newey's map has already been
It's
processed.
already been approved.
okay.
Yeah, and if you remember, one of the conditions in that map was the, getting the rights from the county for the Carter expansion. So I can attest, because I'm in those emails, I'm seeing it, it's happening, it's in the works. But the city has to enter into an agreement with the county. So there's that step still that's happening. But, so these are two tracks happening at the same time. The congregation is submitting their application because under the development agreement, it's a 3-party agreement, the development agreement. Newey, city, and the congregation. The congregation is now doing their obligation to split their parcel and to reserve that northernmost portion for, is it just gonna be open space?
It's open space. Yeah. Okay. Okay, so we are 6 months from design review. That's exciting. We'll earn our pay those sessions. All right, thank you. Anything else? Well then, happy holidays, everybody, and we will see you again on our next regularly scheduled meeting for February 6th, 2025.
Very festive, look at this.